According to Section 27, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. An agreement which unnecessarily curtails the freedom of a person to trade is against public policy. Restraining a person from carrying on a trade generally aims at avoiding competition and has monopolistic tendency, and this is both against an individual's interest as well as the interest of society, and on the ground such restraints are discouraged by law. Further, Article 19(1)(g) of the Indian Constitution guarantees freedom of trade, profession or business. An agreement which interferes with freedom of trade is said to be an agreement in restraint of trade and is contrary or opposed to public policy and is declared void. However, reasonable restrictions may be imposed upon the freedom of trade. Article 19(6) of the Indian Constitution deals with reasonable restrictions. The object behind this public policy is to strengthen the trade and to avoid monopoly. The Supreme Court in Krishna Murgani versus Superintendents Company of India held that a restraint on trade after the contract of employment ceased is void. In Madhub Chandar versus Raj Kumar, 1874, the plaintiff and defendant were running business in the same locality. The defendant suffered, requested the plaintiff to close his business against payment of certain amount. As the defendant failed to pay, the plaintiff sued the defendant. The court dismissed the plaintiff's claim on the ground that the agreement was in restraint of trade. Now, there are some exceptions. Agreements in restraint of trade are valid in respect of the following cases. 1. Sale of goodwill. 2. The Partnership Act 1932. 3. Trade combinations. And 4. Service contracts. Now let's come to the first one, that is sale of goodwill. It is an intangible asset. It is the name and reputation of a business house. This exception enables the buyer of the goodwill of the business to impose reasonable restrictions on the seller of the goodwill. Second is the Partnership Act 1932. The Act provides for 3 exceptions which validate the agreements in restraint of trade. First, a partner cannot carry on any other business except partnership business. Second, an outgoing partner may be restrained from carrying on similar business within specified local limits for a specific period. Third, in anticipation of dissolution of the firm, partners can make an agreement not to carry on similar trade within specified local limits for a specific period. Now, the third one is trade combinations. Traders or manufacturers carrying on same business may form associations to regulate business or to fix prices. Agreements in restraint of trade, if any, in this connection are not void. Fourth is the service contracts. In a contract of service, the employer may impose certain reasonable restrictions on the employee with regard to his freedom of trade. An agreement in restraint of trade, if any, between the employer and employee in that connection is not void. Such restrictions are binding on the employee during the period of employment,